And now I'll turn things over to Arthur. Art, take it away.
Hey, thank you very much, Laura. And I'd like to thank everybody, as I sort of say, good morning, good afternoon, or good evening, as the case may be. Certainly, as our moderator has said, if there are questions throughout, please do use the chat function to send them out. And I know typically we embed your sort of activity codes within the screens, but we have not had a chance to do that, so they will show up in your chat window at the bottom of the screen at least twice throughout today's session. So today's session is how contract management helps transform the legal operations function. Certainly for those of you who have been legal operations professionals, you may look at the title with something of a skeptical eye. Certainly legal operations involves a lot more than just contract management. But some of the topics we'll cover today are how using contract management to help quantify the result of certain key performance indicators or KRAs, key responsibility areas, can help both quantify the value that legal operations brings, but on a broader scale, can also answer some of those basic questions like, hey, what you did for me last month was fantastic. What are you going to do for me today? So let's get started. And again, please ask questions throughout as we go. So we've seen over the years how legal operations really has changed, and sort of the expectations have changed both from internal as well as external pressures. So we'll start off sort of looking at how that landscape has changed out, and then maybe how contract management software, specifically how artificial intelligence powered contract management software can help support the transformation of legal operations. Last but not least, we'll sort of run through an About Ultria, just a little bit of an advertising piece, about 3 slides, and a summary. So there are many, many facets for today's contemporary legal operations organization. And a lot of what we're talking about today really stems from what we've learned from our customers, as well as from the market as a whole, but really some of those large organizations that we've supported. Some of this, I'm sure, is common and expected for many of you. Some of you may find these somewhat surprising. Certainly, and I'll just touch on these briefly, cross-functional alignment has become a responsibility of legal operations teams. It's not that uncommon that we'll walk into a room and see that the legal ops team has coordinated folks from finance audit or finance compliance with IT services and procurement to help analyze the performance of key suppliers. Or in the second bullet, that the expertise is tapped to understand how perhaps a complex deal, maybe a large M&A, may need to be operationalized from a legal team perspective. How to coordinate the e-discovery with the M&A team. Financial management, certainly internal. Legal costs are ever increasing. The pressure on teams is ever more present to reduce costs of either LPOs or third-party counsel. But just as likely, how does one structure deals to be truly win-win or performance-based, whether it be targeted compensation for senior executives or whether this be financial structure for more complex relationships? The thing that we've always associated, records management, keeping track of contracts, keeping track of updates, amendments, schedules, addendums, pretty common, but increasingly also the compliance paperwork, certificates of insurance, or self-certification for security or data privacy. And then increasingly, not just managing those records, but being able to support audit and being able to identify risk areas. This requires a certain level of automation, which sort of jumps us ahead a couple. So we'll just touch briefly on, of course, communications. Communications within the team, external to the team, oftentimes between conflicting parties. Number 6 is one that I was reminded of most recently by one of our customers who heads a fairly large legal team. and so that she's responsible for the growth and development of the team. So not just taking advantage of the educational opportunities supported, of course, through ACC and other organizations, but to ensure that these folks are actively learning and expanding to support both the needs of the business, the needs of their professional growth, and staying abreast of current technology trends. Which leads us to number 7, technology trends. It's great to be involved with understanding how technology can help, but it's not just technology for technology's sake. We all know those people who have the latest whiz-bang gadgets or the whiz-bang software or application or cloud-based app, but it doesn't necessarily align with the needs of the business. So, now more than ever, legal operations is expected to evaluate legal tech, contract lifecycle platforms, artificial intelligence for discovery, but do it with an eye towards how is this going to help the legal department, legal operations, and the organization as a whole. And to support the contribution of legal operations, the requirement to analyze performance data of the team, simple data analytics, but also look at the broader trend to be able to leverage the repository of information, contractual and non-contractual alike, to provide insight and oftentimes risk profiles across an organization's contract base. Certainly, the role of legal operations has expanded dramatically. Now, some of that is from internal factors. Organizations are getting bigger. They're getting more geographically disparate. We're working with an extended supply chain internally of people. You've got teams now that aren't just based in one country. They're based in several time zones, several languages. And this helps adapt to the changing needs of the organization. Whether it's more legal professionals, maybe we're looking for specific expertise for a geography or a technology or a product or a service offering. And part of that also helps the team get exposed to new organizational risks. And without risk, there is no reward. So it's good to embrace these risks. But as we do so, there's an increased expectation from the business to the legal department to help protect the company against these risks. So you're asked to do much more while there's additionally increased pressure to reduce any outsourced services and to reduce costs associated with both the direct legal department, but what we're seeing more and more is to help find other opportunities for cost reduction. Now, the broader external influences that are likely driving some of these internal factors are, of course, the things that you expect. Globalization. The world has not been flat for some time. So the ability to reach out and touch someone anywhere you want, to leverage resources within your own company across the globe, and to do that perhaps to offset the rising cost of legal services, to perhaps incorporate more cost-effective legal service inside and minimize external third-party costs. And we're able to do that, of course, because of the technological, easy for me not to say, advancements. Today's webinar is sort of simple proof. So whether we're running virtual conferences or webinars or video cons, there's no reason for everyone to be physically together. An additional expectation, I think this is certainly something that we've seen very recently, is the increased regulatory framework, not just for the United States, but for other regions and other countries. Changing regulations, whether it be something simple like an IFRS or ASC update, changes to lease obligation or revenue rec, things that we've had to cross or in the process of crossing today, or simply increased awareness of customs export control and the like. So with all of these pressures on legal operations, what will sort of the next generation of legal operations look like 3, 4, 5, 6 years from now? And really, we're starting to see some legal operations team already fulfill this role as a steward of best practices of a disseminator or sharer of industry and peer best process, best risk mitigation procedures, and how to bring this to bear for the legal team and the company overall. I think legal operations will continue to transform into an organization that is carries a center of excellence mentality, right? The best and the brightest ideas, driven by hard facts, key performance indicators that can show how adoption of technology or a change in process or just a change in attitude can bring a higher performing team to bear on almost any problem. Increasingly, legal operations will extend value beyond just execution of the contract. I've often said it's one thing to reduce the request to execution window by 20%. That's great. It's a time saver. It's a labor savings. You could be a month or two ahead in terms of revenue generation. And these are all good, valid ways to validate and in some ways justify expending money on a contract platform or a new process or procedure or training. All good stuff. But if we look at where the big money comes from, it's getting another 3 or 5 or 7% out of that 5-year contract that runs for 60 months and can drive net new revenue for the organization or net savings for an organization, depending on the kind of contract, at a remarkably high multiplier as compared to simply shortening the negotiation cycle. And to look at that, that's where we're looking at evaluating technology, not just for tech's sake, but really for the business value driven to the organization. And helping legal operation teams really become masters of the ROI calculator is sort of key. And not that this is in any way, shape, or form a negative or something we should watch for, but we need to make sure that we are reskilling and skilling our people to help enforce continuing education credits, to ensure that technology is not just adopted, but is used, and to leverage some of the training available through those organizations. Sorry, I was just checking to see if there are any questions that had popped up yet. So, how can intelligent contract management help transform the legal operations team? So intelligent contract management or enterprise contract management helps bridge the gap between operations and strategy in many ways. Certainly allowing organizations to measure their performance, measure the throughput, measure the value add, to help improve the processes involved throughout the life cycle of a contract and the contribution that the legal team makes to the business, whether it is the revenue side, sales organizations, operations, or even procurement. Improving those interactions and the value add is certainly key to that. And parts of that include assigning ownership for the various roles and contributions. Developing that center of excellence mentality. All of these things, measuring, improving, assigning ownership, accountability, responsibility, and developing the center of excellence mentality are all driven by key performance indicators. It becomes something that we can easily communicate to our teams, that we can hold ourselves accountable for. Now, I can't remember who said it, but the old mantra, or someone said the old chestnut, is that which cannot be measured cannot be managed. So what are some of the common KPIs that legal operations teams are faced with today? Let's look at 4 of them. First, reduce contract turnaround time. Seems straightforward enough, but this can be a fairly long and arduous cycle. It could also vary based on the complexity of the contract. There's a recent study by the IACCM who said, for the bid negotiation cycle for a low complexity agreement is under 6 weeks, relatively fast turn. But the bottom quartile stretches to over 8 weeks. So only 75% of those surveyed were able to sort of meet this common benchmark. 25% were significant laggards. Now, it might be interesting to take this intake to close negotiation cycle and split it into 2 parts. The first, intake to best first draft. So the point where a business user asks to have an agreement crafted to the point where the best first draft is ready for sharing. And then the second piece of that, which is the review and negotiation cycle time. So this may be internal review if it's complex and external negotiation. The reason for splitting these 2 is that there are different ways that you might use contract management and technology and AI to facilitate that first part. The intake process is where we see a lot of inefficiencies overall. Typical request comes in from a user via an email, via a phone call, maybe a tap to shoulder in the hallway, but they never give us enough information to actually write the first draft. Hey, I need to sell 1,000 widgets to Charlie over there. Well, where is over there? What country? What region? Which business unit? How many widgets again? And do the widgets need the who's-its? The back and forth is extreme, and we lose cycles right then and there. And why do we care? Well, if it's in a different region, I may need to have a different approval. I may need to have a different contract template. And if it's just the widget, I have an order form you can send. If it's the widget and the who's-it, well, it's a little more complex, and you got to add services. Bottom line, get this information at the start. And that's where robotic process automation, which sounds very, very high-tech, but really what we're talking about are smart wizards that ask the right questions and then based on answers continually refine the next set of questions so that users can very quickly and very efficiently provide you the information that is needed to generate that best first draft, whether that is using a CLM to automatically generate that best first draft, or whether it is simply to navigate through to the right template and right clauses, and then have a legal professional do that final red line review and push it out to the external party. This takes days or weeks out of that intake to best first draft timeline. Now, whether you do this through, let's say, a bolt-on to Microsoft Outlook, because let's face it, change management is hard, so if we let people continue to think they're using email, they're more likely to adopt it, or maybe bringing them through a simple online portal with a handful of steps. And notice that our screenshot here shows 6 steps, because our research shows that if you go more than 6 or 7, people abandon the process and they reach for their phone. They'll reach for their email anyway. And now they'll be unhappy when they reach out to you. So simplify it. Let the AI do its job and refine the series of questions to those that are really needed to help generate this first version. And then for those high turnover positions, where you may have call center or telesales or folks who sort of live in their CRM, customer relationship management platform, whether it be Microsoft Dynamics or Salesforce, let them stay inside of Salesforce. That's where they need to be, minimize their change, keep them heads down doing their job, which is selling stuff. But let the information that you need come from those systems through the same simple questions to enable fast conversion. This will, and we've seen firsthand, reduce your intake process from weeks, as we saw from IACCM, 6 weeks, to days or hours. Next is to reduce that review and negotiation cycle time. This is sort of a labor-intensive window where you may have multiple people actively engaged. A lot of that time is spent running around trying to figure out, where is that agreement? Who's got it? What's next? Did I forget something? Charlie's out of the office on Thursday. I need Charlie to review this clause, and Mary's out on Friday afternoon. I was hoping to get her signature. What you need to provide is that kind of instant visibility, a dashboard, if you will, as you see up on screen, to be able to very quickly understand what is your deal flow looking like. Where are the agreements? Very quickly understand which agreements are due for what stage with whom next, and then facilitate this kind of review through a mobile interface. Enabling automated workflows enables each different kind of agreement, each different kind of template, each business group that you have to transparently and quickly flow documents through the process. And throughout, being able to track and monitor changes, red lines, and of course, ultimately get signatures no matter where you happen to be. Now, we mentioned before, there's a lot of pressure to sort of optimize the costs of legal operations in general, and certainly from a contract management perspective, there are a couple of key places where we can look at cost reductions. Using an intake portal, whether it be through Microsoft Outlook or an intranet portal, right, or from a Salesforce CRM, is certainly a key first step. Being able to triage, to route based on complexity, adherence to policy, difference between perhaps even internal paper and templates and third-party content, and also managing your use of external resources, outside counsel, and the like. Some interesting stats, I'm sure you've seen them before, is that a simple contract, on average, costs the typical company, I know everyone has all of these caveats, but $6,900 on average. Now, that doesn't seem like a lot unless you've got 10,000 contracts. $1 million here, $1 million there. Pretty soon, we're talking about real money. So this initial, robotic process automation, or using the smart wizards to triage and route to the optimal team, is a fantastic way to minimize wasted cycles, and just as importantly, because we've already talked about how to reduce time, if we're looking at reducing cost, leveraging this triage, this self-analysis, ensures that the right costed parties are used to review contracts. This is a standard NDA. It's all in-house. Nobody made a red line. This goes through, no legal review required. This simple sales agreement, it's for a common product to a common region. They're using our paper. The price schedule denotes that everything's within acceptable margins. We have sign-off from the sales manager, generate a PDF, send it out after one check by sales operations or the controller for the region, versus something a little bit more complex. Here we have an example where perhaps we're taking third-party paper, and we want to ensure that the clauses that are embedded in the third party are an exact or very near match to what we have. We also want to identify whether there's any extra clauses or any missing clauses. And based on the sensitivity, route this to in-house legal professional, route it out to our LPO offshore for bulk processing and review, or maybe this demands the review by our outside counsel, or take this inside and work it with in-house counsel. This is based on the ability to compare clause by clause the content from the third party and validate it against the internal clause library. Now, we mentioned briefly the ability to send and to triage or to route contract requests to your business partners. And if we do this through an intelligent contract platform, we have full audit, we have validation, we know what went out, how much effort was put in, whether we want to check red lines or just verify that it was more than comma sprinkling. This gives you full visibility into the downstream process. We know when people have logged in, when they check the document out for review, red line, how many versions were modified and updated. And in many ways, your outside parties can thank you for this because you are now providing data to help validate their invoices. This helps you address third-party legal spend, or at least provides an incremental checkpoint against those invoices as they come in with oftentimes a scant or non-existent detail. Now, it is more than just cost. Right? If we look at compliance, there are a couple of places where legal operations teams are called to provide both sort of an audit as well as a preventative compliance function. In many ways, as sort of curators of the playbook or curators of the clause library or stewards and stalwart supporters of risk modeling, legal operations is in a unique position to help manage, if not create for the first time, a global clearinghouse of accepted language. I mean global within your company, of course. There are certainly organizations trying to come up with common language in Europe, but I don't think we'll see that spread to the United States. The rationale for this is some nice, big, scary numbers. This number came out of the IACCM study, I guess, about 2 years ago. And the number of 9.2% revenue loss on average due to poor contract management practices. So this is a big number. If you are a $10 billion company, we're talking almost $920 million. Your numbers can scale, of course, just picking easy numbers for math. Even if this is a vast overstatement and it's half this number or a quarter of this number, these numbers are huge. And this is from firsthand surveys of companies very much like our attendees today. So by being able to leverage common templates, common clauses, perhaps even going as far as playbooks for sales or negotiation plans for sourcing, risk models for different clause variants to help not just ascertain risk, but also route riskier contracts to the right folks, you can start to really put some hard business value, some measurable ROI into your quarterly reports to your team leads. So many organizations have tried to put these together, and we see them in Microsoft Word. We see them in spreadsheets. We usually see 4 or 5 quote-unquote standards emerge whenever we work with a customer. Ideally, though, your contract management platform, right, your contract lifecycle platform, is built to house clause libraries and knows when to use them, right? That's part of the configuration. And it helps optimize their use during the authoring or assembly process. It can even be used at that intake request level. So based on questions being answered, templates can be populated with clauses. This is not as hard as it may seem. There are partners, there are companies out there like us to help do this as part of the configuration of our tools. Being able to leverage playbooks allows you to similarly manage hints for clause variants as part of your curation right? Part of your control of your clause library. Being able to track any time a standard clause or an alternate clause or a fallback clause is modified by in-house user or even outside counsel or outside the other negotiation or external party, and then route that clause for approval, it's all about minimizing wasted time. I could have a 200-page agreement, 150 pages of that, of course, are schedules, reference, etc. But out of that 50 meaty pages, 10% of that language is meant to describe the nature of the deal, and 90% of it is to basically blame somebody in case things don't go right. Let's intuitively and sensibly route that 10% to those people who need to review it. For those times that clauses are varied, that there are modifications made, or even if you simply have multiple versions of an indemnification or LOL, right, or inbound indemnification versus outbound indemnification, use your risk scoring to help measure risk as these are being authored. You can then risk and cost effectively route to internal approvers. You could also then guide your employees to use the less risky clauses and perhaps provide the hints as needed. Now, that's great to control the process of getting through your best first draft, get the review process with your outside parties, get that finalized secured agreement. But as I mentioned before, it may take 6 months or 3 months to write an agreement. That agreement's going to run for 5 years or longer. So how do we measure post-award compliance, and then how do we assign or attribute value to legal operations? So often, legal operations work does not really end at sign-off. I mean, we can all sort of applaud, hey, we're done, what a deal. But we're looking at the true monetization once that deal has been signed and is now in operative mode. So on day one of contract, post sign-off, really to ensure maximum value, you want to look at operational compliance, compliance to the commercial terms of that contract or the agreement, and also just from a reputational perspective, you have to manage your regulatory compliance. Now, this, of course, all of these things are very industry, very customer, very domain specific. But in very general terms, if I'm looking, let's say again, we'll tag off on a particular study. According to IACCM, 77% of their respondents indicated project delays or cost overruns represented a regular source of loss. This is on both the buy and the sell side, by the way. We think about obligations and we think about entitlements and how those need to be well managed. That is a great use for artificial intelligence to help extract either during the authoring phase or during the review phase, or if you couldn't get it done while the deal was in flight, now that the deal is signed, it is the right time to use your AI technology to read and extract obligations and entitlements from your active contracts. You want to do this for a couple of key reasons. First and foremost, of course, is compliance to commercials. The amount of lost revenue, because no one was watching the contract after the signing, no one was chewing up operational values against the commercial contract to identify either extension of scope or the flip side. If I've got tiered volume level discounts, I negotiated those for a reason. I want to sell more at a slightly lower cost because my net revenue is higher. Let's make sure that we are realizing and recognizing and promoting that next volume tier benefit to the customer before the customer's finance people say, hey, we're supposed to get a discount on that last 150 units. Being able to provide This information up front is good for the sales organization. It's good for the customer relationship. It's good for finances in terms of not having to restate or necessarily have to rebate or refund. And using post-award compliance is something that provides detailed view of commercial obligations on a contract-by-contract basis for each of your individual contracts. Now, commercial compliance is one thing, right? Were we paid on time? Do we charge the right amount? All good stuff. But how about for service businesses? Maybe it's a little bit more gray. We often lose track of service level agreements or commitments for delivery or commitments for the quality of delivered product or delivered service. When we lose track of operational performance, and specifically operational performance that is bounded by contractual terms, we become, I don't want to say lazy, but we certainly lose focus on the end state. That end state, of course, is the reason we crafted a contract to begin with, which is to help reinforce a successful relationship between two or more parties. So by very easily bridging operational performance, the percentage of, the quality percentage of a delivered good, the uptime from a service provider, timely delivery. These are things that help us manage our suppliers as well as hold us as revenue generators accountable to our customers. So contract lifecycle management helps track contract performance and additionally alerts the key stakeholders when there is a gap or a trend for negative day-to-day operational activity. So appropriate measures and metrics are put in place. This is the definition of key performance indicators, which can provide simple notification to all parties concerned as to what remediation or corrective measures may need to be taken prior to a breach condition. That sounds so dramatic, in some ways draconian, but the reality is we took a long time to craft a relationship. We don't want that relationship to sour quickly. Let's make sure the other party knows they're not living up to expectations and do it well in advance. Truly, post-award compliance helps really manage that aspect of the relationship. It's just as important, by the way, for intra-company agreements, division to division, to make sure that everybody is living up to their obligations to ensure a successful customer, client, or industry engagement. Now, last but not least, within the compliance structure are those things that keep counsel up at night. Right? Part of the job of counsel is to keep our CEO's picture up the bottom fold of the Wall Street Journal. Right? So we want to ensure that, as an organization, and also down to the individual agreement level, that we are in compliance with those regulations that affect our industries. Whether it's the CFPB or GDPR, or ensuring HIPAA compliance, OSFI clearance for know your customer, know your supplier. These are the things that are common. For certain industries, there may be things like environmental protection clauses. So perhaps if I'm building a facility, or I am the general contractor to do a multi-billion-dollar automotive fabrication plant in Tennessee, I want to ensure that my filings with the state are exactly as they should be, that my customer has signed off, that my key suppliers, my subcontractors, are providing proof of inspection, proof of intermediate inspection, local certification, and all of that is rolled up and packageable to defend the organization against any claims of either impropriety or regulatory gap. By continuously updating the compliance information in a contract lifecycle platform, we have the ability to continue to update our clause library, those things that are being curated by legal operations, and that further allows legal operations to ensure all templates and all future paper are updated and reflect accurate current regulatory information. We recently had an opportunity to help a pharmaceutical company perform a GDPR audit and identify which contracts had the current and correct language, which contracts had one version prior and needed a simple amendment to correct and bring into the current language. That is a great use of technology, artificial intelligence, to read through contracts, ascertain clause match percentage, assign a risk profile, trigger the high risk, replace with an amendment, and automate that process to handle thousands of agreements in the course of a few hours. So whether this is something such as tracking simple milestones for performance or delivery, adding key metrics for things such as mean time to repair or supply, and then even going the next step, which is to define and or calculate rebate, refund, or upsells. So before we jump too far, let me just do a quick check. I see we've got a number of questions coming in. Also, for those who have not been paying attention, and I'm sure Laura appreciates me reminding folks, your CLEs are in the chat window. Don't forget to take a look at those. Great, I see a couple of quick questions. Let me answer those in just a second. And let me come back to our PowerPoint. And I promised a very quick advertisement, really not very much. So Ultria, for those of you who have not heard us speak before with the Association for Corporate Counsel, we develop and license Ultria CLM, which is an enterprise contract lifecycle platform. We are hosted in the cloud, multilingual, multi-current, full global deployments. We offer a scalable solution for organizations that are both at the upper end of the mid as well as large enterprise. We provide a full platform for really what we would consider the full life cycle. Everything from intake, or the request to have an agreement drafted, through the automation of the authoring, the drafting, internal reviews and approvals, automated workflows, version control, and external communications for negotiation and sign-off. We'll come back to why AI-driven CLM in a minute, but let's touch on a few of the questions that the audience has raised, which I managed to, of course, clear off the screen. There we go. Let me see. Question one, on average, how long does it take to set up this type of system? Okay. For an enterprise CLM, depending on the number of domains, templates, clauses, we've seen anything from, and you may laugh at this, anywhere from 11 to 16 weeks. And that's simply because we are an environment where we configure for everyone, we customize for no one. So we've got a core platform that is scalable, built, runs incredibly well. What it needs, of course, is your input. So for your clauses, your templates, the population, the loading up of your documents, we have a tried and true process to help run through the interrogatory discovery. And then the rationale for us being so quick is quite simply, we have an agile methodology for our configurations, so that once we begin, you'll see incremental changes every 3 to 5 days against the live system. So that the back and forth that is typical with most integration approaches, and certainly with most development approaches, is totally bypassed. For us, it's really about almost like test driving your car and changing it as you go. I like different wheels. I want a different interior. I want it to be a larger wagon. Nobody has station wagons anymore. I needed to have kayak racks on top. For those of you who know me, I'm a kayaker. All good stuff happens in real time. This way, you make a request, we see it in another day or two, and that makes this process very straightforward. It also enables larger scale or multi-divisional rollouts, so that the ability to have parallel work streams for core legal versus sales versus Asia Pac, product manufacturer, all be configured in parallel and at the same time. Question from the audience, do you recommend legal team keeps track of compliance after a contract is signed or another area of the organization, contract owners on the business team, for example? That's a great question. I'll answer that just by saying, ideally, there are different kinds of compliance. So in the scenario that was just asked, right? So post-award compliance, where should it take place? Should it take place in legal operations or should it be with the business owner? Business owners, I find, will manage to the commercial terms only, and generally that's great for sales. It's surprising, though, that we've often been asked to use our AI engine to help with analytics to provide insight and profile to those business users. That should be supported by legal operations in my mind. So although the primary responsibility for commercial compliance may rest with the business owner, I think it's a great place for legal operations to offer their support, their guidance, and maybe even sharing some of your peer-based knowledge and best practice with those business owners to ensure that they are doing it smartly and doing it well. By using the same compliance framework for commercial compliance as regulatory or risk or finance may use against the same contract, I think you'll find a more streamlined process, a more cost-effective audit process, and generally better business value as well as perception of value for legal operations contribution to the business. Now, if I'm looking at ICA, let's say intra-corporate or intra-company agreements, this could be intellectual property transfer, license transfer, could be just for a vertically aligned business where you've got separate reporting organizations, maybe financial reporting based on region. There certainly, I think, finance in hand with legal operations takes responsibility for ongoing compliance. There, the model can be a little more complex. Certainly, there's more internal politics, as much as we would think we could avoid those in today's age. They're certainly alive and well, and if anything, they are now more fluid and supported by technology advancements. But likewise, the defense against that, as well as the reinforcement for positive compliance action, is enabled for legal operations through technology advancement. Leveraging artificial intelligence by legal operations gives the team both access and control of access for other business groups. Well, I happen to be on this slide anyway. It's a great way to sort of map this across to say why legal operations with post-award makes good sense. It's with central control, we know what's been touched. You know what's been touched and why it's been touched. Ease of access is a double-edged sword. You want to provide the access to people so that they can learn from what's been done. They can impact positive change to what might be in flight. And just as importantly, you can extend centralized control to the edge of the organization through ease of access and ease of use to those business parties that have the best knowledge of the requirements to create relationships with people outside the organization, with your trading partners that are customers, with your trading partners that are suppliers, with knowledge partners that may be regulatory agencies. If I'm in the oil and gas space or the energy generation or the natural resources mining space, in many ways I need to look at or consider the regulatory agencies in some ways as a partner. Right? It's not just financial audit that I need to worry about as being a good global citizen. These are organizations that, when worked with, can be helpful. So even providing a level of limited ease of use collaboration with these outside parties, not always customer supplier, but sometimes regulatory, can be a tremendous enabler. and a streamliner, and a way really to raise everybody's game. By providing collaboration and a connected environment that is both guided through artificial intelligence and where AI can be used to limit exposure to sensitive data that may have otherwise slipped through the cracks, through the ability of AI to read contractual context, helps provide a safe sandbox for everyone to play in. So I'll take one more minute to see if we've got additional questions that have come up. We're getting towards the top of the hour. Okay. Okay. I just had a very valid question, which is not everyone has hit the level of contract automation where post-award compliance is top of mind. Basically saying, how does legal operations get involved at the more nascent or maybe less mature stage of the contract lifecycle? So if we are looking at an environment, let's say, where the fundamental is reducing contract turnaround, how to automate the process or streamline the process or simply develop a more consistent process for having agreements crafted. One of the things that CLM brings, and I think this is certainly true. Let me say there are three things. The first is leveraging artificial intelligence to intake third-party agreements or third-party paper. It's one of the higher cost processes we see. Third party comes in, it sits on a sales guy's desk. He doesn't know what to do with it. He wastes time. He alienates a customer. Finally gets around to sending it off to legal operations. Legal op has to open it, look at it, ask 7 questions. Who is this contract with? What are you thinking of selling them? None of the details are in their paper. Of course not. It's their paper. So using the intake portal, whether it be the bolt-on to Outlook or a simple intranet, it enables that transition to occur faster. One, with a little bit of training, the salesperson knows, oh, this is third party. I need to send this to legal. I need to add these little bits of information. Who's it going to? What do they buy? Any special terms? Anything that I'm already aware of? Hit the send button. Get it routed. Okay. Then letting the AI engine disassemble it and understand how far off is this third-party paper from your common practice. Now, to the person who asked the question about, process compliance or post-award compliance being a little much of a future state for them, even at the initial states, being able to disassemble and understand a third-party contract will enable you to intelligently, time-effective, and cost-effectively route this to the right person for review. If it's not that much different from what you use, maybe this could be handled within legal operations. If this is a different kind of paper and it's looking at governance in Brazil, maybe I need to send this to outside counsel. But let the software give you that guidance. It can read it a lot faster than you can. And generally, we're pretty accurate. And that can help streamline that process and can ultimately drive, internal brand improvement for legal operations to those other business units, but ultimately may help drive better response times to your trading partners. One last question, two last questions. Sorry, bear with me, which is great to see questions coming in. Okay, audio question. What are my thoughts, overview on eDisco or eDiscovery? And who said Disco was dead? I'm sorry, I'm going to get grief for saying that, I'm sure, later. There's a time and a place for electronic discovery. There have been providers out there whose main job has been, let's say an M&A scenario or a large audit scenario, to take a contract repository and rip through it for certain abnormalities, or simply to look at particular clauses. One of the reasons that Ultria implemented its own AI engine was because we saw a need for the intake process to be more cost and time effective. So by enabling an artificial intelligence parsing in addition to natural language processing around OCR, and I'll be very careful there not to use too many TLAs, three-letter acronyms. E-discovery requires searchable text. Even our disassembly of contracts using our AI engine means that text has to be readable. So what we've done is we've implemented a natural language processing engine. It's a simple form of AI that wraps around optical character recognition so that images, let's say old scans or old PDFs, can be converted to text. That text is then loaded to the repository so that you can search and find anything you need, but it's also great input into contract analysis. So where there may be bespoke or specific discovery software service pairings out on the market today, we also offer, as part of our native contract lifecycle solution, built-in AI that can be configured to look for certain kinds of clauses. GDPR, revenue rec, lease obligation. These are some of the simple examples that have been popping up on our customer radars over the last 12 to 24 months. So overview on eDisco is if the volume is small, or even if it's not, if it's in a repository, and if it's in our repository, for instance, the AI engines work fine, and they do a great job. There's normally some configuration and reporting required. If eDisco is used for evidentiary support, there's a slightly different formatting, and that would generally, even from a company like us, who is very focused on the CLM software, if we were supporting a customer for eDisco, we would certainly do a one-off project for ensuring that any results would stand up and be comfortably read by a jury or by a judiciary body for evidentiary understanding. I'll give you a caveat now before we end the recording. I am not counsel, so don't want anybody to think that I just signed up or swore to how something should be moved. Also, I think just as a reminder to the team, and I know Laura went to mute, make sure you check your chat. I think there's another CLE code at the bottom. With that, we have a minute to go. I am simply going to thank everyone on the call, all of our attendees. If there are additional questions with respect to a lot of what we covered today, which were key performance indicators and how using KPIs, specifically 5 pre-award CLM metric KPIs and 5 post-award metrics for effective contract management, there are links on this page. For those of you who have attended, you will, of course, be able to download the PDF and then click on these fantastic links. The presentation I used today had some minor changes that may not be reflected in the PDF, but these are certainly there. On behalf of Ultria, on behalf of ACC today, my name is Arthur Raguette, one of the founders of Ultria. I thank you for your participation and for your most excellent questions. Have an excellent morning, afternoon, or evening ahead. Thank you very much.